Professor Poversky, Professor Burra Srinivas, and myself. I think we have 1 hour around and 15 minutes each speaker, so I would like to request you to start your presentation for 15 minutes and 15 minutes each, and then 2 students speakers are there. We'll request the speakers after we finish, and then floor will open for the question answer session. And also like over the years, so this is the pattern which we will follow, but over the years change has taken place, and change which is very much visible, particularly the system of seating arrangement also has changed. So from traditional model to the new model has come into place, and it's a big challenge for the person who chairs in a new environment to maintain the rhythm which we used to have in the half of the portion was guarded by the sitting arrangement, but everything is here like it's open. And but I want to thank the first time we have seen that efforts taken by these very young lawyers to organize a meeting in a big manner. And I want to congratulate all those who are involved, and particularly Ankit and other his friends, for taking an initiative, organizing an international conference, and it has come out in very nicely, and I'm sure the participation which we witnessed. And this is the first time where we have seen without the support of any big organization, big individuals. So this is the actually needed. In today, the young people has to come forward, take initiative, and so we have now the second layer. Otherwise, like now we always see a gap. We have only the first layer, and then first layer finishes second, third, fourth, every layers. So now we have a second layers. So I'm very happy that young generation is ready to take initiative, started this kind of activity, and whatever limited ways we can contribute, we can support, it's there from our side. That you can take it granted whenever you need any help, and I'm very happy that our colleagues have responded positively. So now I request Poversky to...
Thank you very much, Manoj, and thank you to the organizers for this kind invitation to talk to this panel. I feel very proud to be always in the Conference on Foreign Policy. And certainly the issues concerning refugees and migrants is very high in the priorities internationally, not only in India, not only in the region, but all over the world. And we see this almost every day. If you look at the news of almost daily and weekly, we find humanitarian catastrophes resulting from civil wars, from conflict, from violence, terrorism, but also, in addition to that, people on the move from various other reasons, such as environmental degradation, climate change, natural disasters, and so on. And often the question is whether the international law as we have it, the Convention from 1951 and the Protocol in 1967 on refugees is a sufficient legal framework, to put it this way, to protect refugees, but also the Convention on the Protection of the Rights of Migrant Workers, more recent one, can be seen as another legal framework as to assess the protection. As you probably know, the 1951 Convention was adopted in a different historical time. It was mostly about the refugees out of the First and Second World War, and it had the limit of geography, but also the limit of substance. The limit of geography was mostly in Europe, and the limit of substance was it applied only to people who have well-founded fear of persecution based on ethnic, religious, and national identity or social or political group. So as you can see, this was very much the spirit of the time. As you may know, the Universal Declaration of Human Rights pronounces individual rights and freedoms, but even before that, after the First World War, we have already the notion of rights of minorities very well expressed during the time of the League of Nations. And also we had the Genocide Convention in 1948, which also make a strong emphasis on protecting and punishing acts of genocide or acts of extermination of particular ethnic, religious, or national group in whole or in part. So there is no surprise that back in 1951, only people belonging to ethnic, religious, or national groups or social or political groups, which is already an extension in the Refugee Conventions from what the Genocide Convention did not include political groups. Mostly the Soviet Union was against that at the time. But the Convention on Refugees include also group on social or political opinion. And what we still don't see at that time is victims of general violence or civil war, which happened later in 1967. We have a protocol which makes the protection universal. It's no longer geographically limited. And again, I would say it's not surprising that it happened in 1967. The Vietnam Wars produced massive migration and refugees crossing borders, displaced populations, the Israel-Palestine War, or general Israel-Arab War in 1967 produced massive Palestinian refugee populations. But also what we experience is what is called protracted refugee situations. Refugees do not simply spend 5 or 10 years in another neighboring country to return back, but they stay for 30, 40, sometimes 50 years in another country. So that if we try to think of the challenges and tendencies which we experience over those decades, we'll see that the protracted character of refugee population is a major concern, which was not the case back in 1951. And we also have a situation where protracted refugees meet the new refugees who come from civil. If we look at Lebanon, for example, Lebanon is a small country in the Middle East with its own population is about 4 million. It already hosted Palestinian refugees for many decades. And now Lebanon is experiencing a new influx of Syrian refugees. So the old refugees cohabit with new refugees. Another tendency is interesting, which is somehow the dividing line between refugees and migrants become very thin or even blurred. We have refugees who do not longer stay in the camps where originally they were protected, but they move. So somehow refugees become migrants. They try to cross borders and find better economic conditions somewhere else, which, legally speaking, they lose their status if they cross borders and illegally migrate to another country. And here comes the challenge for the international community, already realized those days, that there needs to be some new understanding of the tendency of refugees becoming migrants. How to deal with those who might originally left their countries because of genuine fear of persecution, but who do not stay in the camps where they are offered shelter and food and medicine, but they are looking for better living conditions, which is very normal for every human being to look for a better standards of life, and they continue crossing borders looking for better lives. Shall we expand the protection of people who only fear persecution to people who simply lack basic human security. That's a very often question which is asked. So in other words, if the original scope of the definition of refugees was about those who fear persecution, so it's very much about fear of being arrested and tortured and denied even social, civil and political rights, to protection of people who might experience other violations such as gender discrimination. We had a previous panel today. Gender discrimination was not originally in the scope of the convention, so those persecuted because of gender differences were never actually protected under the previous regimes. But we may experience that due to differences in various parts of the world, people may migrate because of other type of violence, domestic violence or general violence, civil wars, victims of environmental degradation, natural disasters, organized crimes, and so on. And here is the gap. Migrants are usually denied the status if they are not employed, because the Convention on the Rights of the Migrant Workers protect them only if they have employment. And if states continue to interpret conservatively the text of the 1951 Convention, for only those who fear well-founded persecution based on ethnic, religious, and national minorities, on political and social opinions, then there remain a gap between one group and another group. So how to close the gap, if you want? Are there any chances for that? Well, there is a good news and a bad news. The bad news is that states continue to look at their obligation very strictly or conservatively. Normally they don't want to accept refugees, and they find all sorts of excuses. Very often it is that those refugees may create security problems, they may not be able to integrate in societies, they may develop certain types of extra criminality. So we see those statements quite often, and for some reason in countries which traditionally have been very liberal, European. I'm a bit ashamed of, I'm coming from Eastern Europe myself. In my own country, Bulgaria, I hear our politicians talking exactly the same language, that those migrants from the Middle East will create national security problems, they will rape our women, they will take our jobs. And this is shameful, because if our own people would like to migrate and go to another country, I don't want Bulgarians living in Western Europe or United States, Australia, or wherever they are, to experience the same stigma and as we domestically would treat people who are coming from Afghanistan, Somalia, Syria, and so on. So there is not much positive development, I must say, in terms of understanding the challenges, until very recently, and I will finish in a few minutes, by showing few examples how various courts, but also United Nations documents address the challenge of refugees becoming migrant, to put it this way. We have decisions in domestic courts, in international courts, most notably the European Court of Human Rights several times, in particular cases, where they found violations of human rights based on states refusing asylum-seeking status. Also, another positive development is that in the Sustainable Development Goals agenda, the so-called Agenda 2030, we see texts such as achieving dignified standard of living for every person, so nobody is left behind. Very strong consideration on the importance of have life free of extreme poverty, inequality, insecurity, and injustice, which one can easily apply to people who are on the move, to refugees, women and children, and so on. We have a text also saying facilitating mass mobility, which I find very crucial, has to be taken seriously by governments, and create international mechanisms to govern migration and mass mobility in a proper way, legal and political, including, and social and economic, certainly, with respect for human rights and human dignity, including rights of education, rights.
When the first convention came into existence, of course, it was specifically for the European context, with a specific time frame also. So later on, they were amended to include geographically extend to the entire world, as well as in terms of time frame, it has been done away with this requirement. Now, the first concern when the convention was in operation, yes, of course, it was essentially in terms of addressing the reconstruction of Europe. It is from the point of view of a critical angle if you look at the convention, but it was mostly in relation to addressing the refugee crisis that in fact erupted after the Second World War. So there was a welcome attitude from most of the Western countries, including the European countries. But that time, most of the developing countries, in fact, had the difficulty in terms of looking at the convention as to how does it fit into, was it really fitting into the concerns of the most of the developing countries? It was really not. Now, if you see that from 1951, several developments took place in terms of relooking at the convention itself. That is the reason why you have other legal documents coming into existence. That is the reason why you have African OAU Convention with regard to refugee protection, which expands the definition of the refugee, which is not the case with the 1951 Convention. Now, in Asian part also, of course, this is not a legally binding document, but you have ALCO adapting Bangkok Principles, which in fact is a different framework, which is different from the 1951 Convention. And you have a Cartagena Declaration. So why when you have a Universal Convention of 1951, which has been expanded by amending it, why there are other attempts to bring in a different way of looking at the refugee problem? The reason was simple, that in fact the 51 Convention was not able to address the concerns of most of the world. And 51 was specifically meant for, of course, Europe. It was extended, and others were finding it difficult to accept that. Now, if you look at the convention from now, that is from 2016 point of view, if you say that whether there was any progress, probably one can say that there was no progress. No progress in terms of addressing the root causes of the problem. Now, the question comes in is that why should we want to address, in fact, the root causes of the refugee problem? Now, that is one way of looking at it, because that has to be looked at why refugees are in fact produced at all, why people flee from one country to the other. Are there any fundamental reasons, in fact, of conflict? Primarily conflict. But why the conflict erupts in some parts of the world, why not in other parts of the world? And why people from one part of the world where the conflicts are happening want to move to a particular part of the world? Now, there is a politics of how you will have to look at the convention. So from that point of view, we will look at whether in terms of addressing the root causes of the refugees was addressed in the last 6 years, probably the answer can be emphatically said no. Now, one way of legally arguing that, but why as a lawyer one has to look at the convention from the point of view of looking at the root causes of the problem? Okay, assuming that, keeping that question aside, when we look at the convention itself from the point of view of as a legal obligation, whether it has really addressed the concerns of everybody, probably the answer is also partially true, in the sense that partially yes, partially no, because that is the reason why you have different conventions coming up. But what were the major concerns what is still the major concern of the third world, or the global south, so far as the convention is concerned, is that why there was a complete welcome to refugees from roughly 50s to late 80s till 90s. Why there was a kind of an unwelcome attitude coming from certain parts of the world 1990s. So one way of looking at some of the important scholars from this part of the world, from India, argued that in fact refugees have served the double purpose for those 30 or 40 years. One is that in terms of reconstructing the European part of the world, in terms of cheap labor, in economic sense. The other was also it was serving in terms of political interests of Europe showing it, or North America showing to the world that we are a free society. So there was a large number of refugees moving from erstwhile Soviet Union and Eastern Europe getting into to the Western Europe part of the world. Then you have to look at it that politically you are also scoring a point against during the Cold War time. As the Cold War ended, and also in terms of changes in economic structures, you do not find as a kind of a viable this thing to invite refugees in terms of as a cheap labor, because you have already probably sustained that what in terms of economic sense. And politically also it was not really serving much of the purpose. And in added to that is that the most number of the conflicts are taking place in the post-colonial world, whether it is Africa, in Asia, large number of refugees are being produced from this part of the world, of course again Middle East. So in that sense, now no longer really the refugees are welcome for most part of the developed world. Now that is the reason why, of course, fundamentally the nature of the refugee situation is that immediately you move to the other side of the border. You don't see that whether it's a good country or a bad country, economically rich or poor. From there you would like to move. That is how from North Africa to Italy and other places people move and die on the way on the sea. So that is what largely the situation is. That now how those countries who have become parties to the Refugee Convention found that this convention somewhere the impact of the convention has to be reduced. Is it that it's a political or a policy decision, or is it happening somewhere from the point of view of law itself? Now I see it the way the international law is developing. The restrictions on Refugee Convention are not really coming as arbitrary ones. In fact, they are coming as legal implication, not exactly legal implication, by way of bringing in a new law, which in fact, in a way, indirectly curtails the movement of refugees into the Western world. Now, how is it happening in the last, roughly, you can say 20 years or so, from 1990 onwards? Let me take two examples as to how these things are happening across the world, especially in the first world. Is that now one is with regard to the construction of walls and fences. Now there is an interesting, one scholar has written that in fact what is the role of the walls and fences in international law? When we talk about wall, immediately we think that Israel constructing a wall in the occupied territories in Palestine. That is only one example of it. In fact, there are several walls and fences are being constructed by the Western world. Spain does it in some of its enclaves in North Africa. United States has been constructing a long wall between itself and Mexico. Turkey did it. Greece, in fact, it was suffering from economic crisis, but in 2011 or something, they built a long wall to prevent refugees and illegal migrants. Turkey started in terms of their argument is that these are the restrictions which are being put in to prevent illegal immigration into these countries. Now, any form of, like, it doesn't come as a prevention of terrorism, refugees. It is coming as prevention of illegal immigrants into Western world. Now the language has changed, its implications are different, but what you are trying to prevent is you basically preventing refugees. Why it leads to prevention of refugees, I'll come to that point. The second example that I take is that criminalization of some of the aspects of international law in the form of preventing crimes in the form of international crimes or transnational organized crimes. One example is that trafficking and smuggling of migrants. Now we have an international law, transnational organized convention, having two protocols, one dealing with trafficking in women and children, and the other one is smuggling of migrants. Both are international treaties. Now if you carefully look at these two international treaties, the structure of these two international treaties is that essentially they focus on the prevention of the trafficking in women and children, prevention of smuggling of migrants. Now it looks like a very fair way of dealing with it, but its legal implications really directly hit the Refugee Convention. The reason is that these two conventions bring in certain restrictions or certain obligations for the authorities of the states. In the sense, one example is that there is an obligation for the carriers, in the sense that airlines and others, to take care that the people, people should not be trafficked and people should not be illegally smuggled. Now it is the responsibility of the carrier. Now under international law, I don't think any of the domestic laws, you can say that the carriers, the airlines would be responsible for the immigration exercise. That is not the headache of the airlines companies. In fact, but the restriction is that both the protocols put restrictions on airlines also. If some people traveling as refugees from one part of the world to the Western world, they would be fined. In fact, it happened. Some people travel from this part of the South Asia, Sri Lanka. Many people travel to London, and they found to be not having proper documentation. So airlines were fined. So now what happens is that what general function of the state is being given to the airlines, private entities, where in fact they would check your documents whether to go or not. Now why it is problematic to the Refugee Convention? It is problematic because in almost all the cases, or you can say the majority of the cases, refugee movement happens without proper documentation. In a conflict takes place and it is legally permitted. The convention provides that the people can move from now. You don't, when a conflict happens, you don't go with a passport, because you may not be having the passport, but you have to escape from the persecution, so you cross the border. Now it is permitted. Now, but when you want to cross the border, then there are other forms of criminalization happening, which is preventing the movement of refugees. So there is, where in fact, large number of refugees are accommodated in the last 50 years or so from different countries, and still there are a large number of refugees in India. Now, yes, of course, that is a kind of a moral obligation that one would be taking it, but as a legal obligation, I think states should become, by way of exercising, by way of arguing that, of course, the existing convention structure has to change fundamentally to serve the interests. The serving interest is, I mean, when you put it in abstract sense, it might not be making a sense, in the sense that who qualifies as a refugee? That is a fundamental question, that whether the conflict-related people, the kind of the refugees which are being produced from this part of the world really would fit into the refugee definition or not. And the existing structure really puts in burden on other countries. Now the question, the structure of the convention is such that other states have an obligation. There is no kind of, as Professor Vasilin has said, that the question of burden sharing. That is where I started, is in terms of looking for the root causes of the refugee flow. Why one has to look at for that is, what are the reasons for the conflicts at all? And I mean, where from the reasons are coming in? Like if Rwanda happened, that the people have moved from Rwanda. Now the large number, there are well-established studies to show that in fact is a legacy of the colonialism. Now whether you want to have the burden for the Western world, or for those who in fact the policy decisions that are taken by someone who are leading to the conflict which are producing refugees. So there is an obligation for the world as such, and the first world much more than the third world, that because in fact most of their policies which are producing, creating conflicts which are leading to the production of refugees. That is one aspect of it. The other aspect is that, of course, the larger political economy question of it, that when there is an overwhelming argument that in terms of investment and others, in the free flow of capital, but why can't there be a free flow of human beings? When you emphasize so much on the investment has to move from one to the other, then let the people also be moving from one part of the world to the other in terms of both migration and refugees. I mean, why should there be a different criteria for the movement of people? You have so many restrictions and your borders become so significant. But when your capital has to move from one to the other freely without any restrictions, every day you demand that there should not be any form of a restriction on capital. So I'll end there.
Thank you, Srinivas. And you have addressed many aspects, and we admire you for your always third world approach which you take, and you think about the South, and your focus is on that particular aspect. And what you have highlighted, then in addition to the convention what we have, so states from the member states of the ALCO, they have Bangkok Principle. So we hardly discuss about the Bangkok Principles, which is very important because India, Pakistan and many states have accepted. So they have recognized the refugees according to the Bangkok Principles, which talks about the gross violation of human rights is also one of the causes for the refugees. You discuss about of course, strict border control is a common phenomenon is there in the worldwide, strict border control that has become, and I like very much the criminalization of international law that we have to see and discuss with you independently what you mean. And then you have also focused on the trafficking, career liability, so various aspects, how they are also coming into the conflict with the refugee instruments. So these are the points from the both speakers. So let me begin with my presentation for 10 to 15 minutes, focusing on some of the points which I have in the mind. Let me start with the origin of the refugees. So most interesting part of the development of international refugee law, it was with the idea that refugee is not a permanent phenomenon. It's going because whatever the refugees we have, it's largely because of the two world wars, World War I and World War II. So people, those who were involved in the development of the international refugee law, as well as the institution, that United Nations High Commissioner for Refugees, which has mandate to ensure that implementation of 1951 Convention. So from very beginning, why 1967 protocol has come. So idea was that the refugees, nobody thought that this problem will become a big problem in the end of the 20th century and 21st century. So in the time of 1948, so refugee was addressed from the 1922 onwards till 1951 more in a ad hoc manner. You have number of arrangement between 1922 starting with tenants and passport, and then finally we have 1951 Refugee Convention there. So, and mandate for the UNHCR was also initially for 3 years. UNHCR will address all the refugees, put them in the right place, their nationality issues will be addressed, they will be rehabilitated, UNHCR will over after 3 years. Unfortunately, that continued. Now UNHCR has a permanent mandate. And this also can be reflected with the idea that 1951 Convention was not addressing refugees in other jurisdictions, I mean other continents, means Africa, Asia and other. They were more concerned about the East European countries. So 1951 Convention, from beginning, it had two limitations. The first, temporal limitation and geographical limitation. It says refugees from the East European countries, and second, refugee prior to the 1st January 1951. Convention entered into force into 1954, but it had a mandate to address the refugees prior to the 1st January 1951, not after 1st January 1951. So we see that this convention was also in that limitation, but subsequently the problem, Hungary refugee was a big problem in 1956, and the 1967 protocol, which has come later on, which has removed these two limitations, the temporal limitation and geographical limitation is there. The causes of war was the first cause for the origin of the refugees. Subsequently today we see conflict. Conflict is the major source of the refugees problem worldwide. And third, what we see, conflict leads to the refugees and another kind of problem, that is internally displaced person. Today, as a matter of fact, we have more internally displaced person in comparison to the refugees. So we have to relook into the adequacy and inadequacy of the existing 1951 convention, whether that convention is sufficient to address refugees as well as the internally displaced person. So more focus should be on the internally displaced person, because we have 65 million internally displaced person, whereas we have more than 30 million refugee population at present. So internally displaced person is there. Refugees, the causes of refugees, we know the conflict, gross violation of human rights, and gross violation of human rights I address. Refugee is actually, it's a violation of human rights. It's a violation of principle of non-discrimination. So if a state persecute a person on the ground of race, religion, nationality, political opinion and membership of social group, that is very much part of the all human rights instrument. So all human rights instrument speaks about, emphasizes on the principle of non-discrimination. It says states should not, while implementing human rights, not for ensure that it's not applying principle of discrimination. Non-discrimination is the buzzword, important one. So principle of non-discrimination is very much part of all human rights instrument. And then when you look into the definition which is available into the 1951 convention, which says a person who has well-founded fear of being persecuted on the grounds of race, religion, nationality, political opinion and membership of social groups. So these 5 grounds were there. And the third, has crossed international border. If you fail to cross international border, you have a fear of persecution on the grounds also, but you are not refugee according to the definition of the 1951 convention. And those populations become internally displaced persons. So persons who have a fear of persecution, fail to cross international border, there is no protection. They have a protection from the same state which are persecuting, same law which is discriminatory. So that kind of challenge we have. The another problem why the all of sudden control of border has become very strict. It's largely the refugees, like the developed, so migration or refugee or migrant workers, it's from the developing world towards the developed, like it never is a opposite. It's not from the European countries to India and others. So we are welcoming the refugees, but we have never refugees from any East European countries. We have refugees from the poorer nations, like from Afghanistan, from Bangladesh, from Iraq, Somalia, Sudan, and Central African Republic, Congo. These are the states refugees come to India. We have never received refugees from Ukraine. We have never received from the Uzbekistan. These refugees are again migrating to Poland, Spain. So East European populations are also moving towards the European countries, like West European countries. And so destination has become a big issue. So migration of the refugees from developing to developed, so it is linked with the permanent settlement as well as the economic regions. So that problem has become a big concern for the European states, which were actually instrumental in the developing of the refugee law. So in fact, they were the creator of the refugee law, and subsequently they started finding the implementation of 1951 convention is very difficult to distinguish between the genuine refugees and fake refugees. So genuine refugees and fake refugees. So there is a procedure which we are not going to discuss. Fake refugees means they are economic migrants. They are not refugees. They are failed to satisfy the conditions of the refugees. So that is the reason they started creating, and because it also affects the society. And today, the another important element has come into protection of refugees. That is the national security. Terrorism has become so that also affects entry of the refugees in many countries. So European states have become these current developments which are taking place. So economic regions, then terrorism, national security has become also very important. The most stumbling block for the accepting the 1951 convention, particularly in the Asian contents, that is the principle of non-refoulement. Principle of non-refoulement means repatriation. It has to be, once you admit a refugees, and then it's a refugee has to decide, even a condition which has compelled him to leave his country is no longer existing in the state of origin. So in that particular time, host state will understand or believe that these refugees will go back. But if they decide to continue, receiving state has no say to send them back. Repatriation has to be voluntary. So many countries find this is difficult. In South Asian countries, largely India has given a statement in many places, even in the EXCOM. It's a socio-economic regions. Largely, we have our own population, huge population. So once you admit a new population, identify them as refugees, you start taking care of their economic and other needs, education, health, shelter. So once a new population has added in existing population, then economic social rights become very important, and it depends upon the resources. That is the reason it has been argued by many developing countries that refugee is not the only concern of the receiving states. Refugee is a global problem, so it has to be resolved globally. So all states, international cooperation is required to handle, and that is the reason we argue in favor of the burden sharing. So even if we receive a large number of refugees, it has to be shared. It's a proximity of the border, so large number of people are coming to India. But it should not be only left to the government of India to take care of the refugees. It has to be supported by the other state, whatever the possible way is there. Then that is the major problem in the European context. We see the fake economic migrants number have increased. They are not genuine refugees, and their populations keep on increasing. One point of time they find it's perfectly fine, so they started accepting the refugees. Then also the very important element, as I said, that refugee is a human rights issue, and if you look into the jurisprudence of the refugee law worldwide, and the protection of the sum of aspects in the first session and in the second session also. So when we look into the definition, there is no definition which include gender-based persecution. If a persecution, a woman is facing gender-based persecution in her country and she moved to the another country, definition of 1951 convention is not sufficient to protect her. And also the LGBT ground has also, people have moved from Iraq, Iran, other places to other countries. But what we see, and it's an interesting part, the national courts have played very important role in development and expanding the definition of the 1951 convention to provide the protection to the gender-based the women who has faced persecution. They were given protection under the 1951 convention by expanding the definition of membership of particular social group. So membership of particular social group has provided relief to the women in many cases, and also the members of the LGBT in number of countries. And a strong jurisprudence has been developed by the USA, UK, Canada, and New Zealand. These countries have played very important. If you come back to your own country, it's the Supreme Court of India has developed a strong jurisprudence on the constitutional law on the protection of the refugees. So we are not party of the 1951 convention, we are not party of 1967 protocol, we are not, but still refugees are protected. Many cases refugees have deportation order has been cancelled, government has been compelled to accept the population. So we see that protection has come through the human rights instrument, the protection has come through the constitutional law also is there. And what we have now, so then the last couple of points which I have in the mind, the 1951 conventions, it focuses on the individual refugees. It's not collective. So now we have, due to the conflict, mass movement of people. So huge number of population from Syria has come to the near to the Greece and Turkey, and then they intend to go to the other countries. So whether 1951 convention will be able to address these refugees, so it's become a big concern. So 1951 convention has a mandate to address individual refugees. So what we are doing in India, so if Afghanistani refugees are coming, or people coming from the Syria, they go to the UNHCR office, they put their application, they appear, so there is a process which is called Refugee Status Determination Test, RSDT, Refugee Status Determination Test. So a legal officer, they appear, they narrate their story, they give all the incident, this happened, and they say, okay, you qualify according to the 1951 convention. But what about the people, mass movement in the Syria and others, where you become, we have to think beyond, not the 1951 convention, and where we have, so immediate concern, their shelter, protection, health, these are the issues, and then finally settlement in the wherever they can be adjusted. So it's become more new approach which has come and which adopted by the UNHCR is interagency cluster approach. Interagency cluster approach, the humanitarian institution like ICRC, UNHCR, WHO, FAO, UNICEF, UNESCO, these all institutions working in the Medicine Sans Frontiers, they all together, and they are trying to help the mass movement of the people in the refugees. So they are the refugees, but it's difficult to follow the 1951 convention. They are addressed through the more in a collective approach, and then also we have some point which we missed. That is, I wanted to hear from about the decision or the taken by the European Union. So current crisis is more with the response of the European Union, how European Union has responded. So there are a lot of issues are there. Just I'll conclude with saying that.
Just a quick response to a couple of questions. The first was with regard to the Indian legislation which is coming up with in terms of accepting some as kind of legal and illegal part. And precisely that is the reason why I think somewhere at a particular point of history people have taken position that India need not become party to the Refugee Convention. But I think this kind of situation probably was not perceived. If had there been an obligation, if India is a party and it has an obligation as part of international law, probably the legislation, the way it is coming up would not have been there. So in that sense, I think somewhere some of those who take the position that India should not be a party have to relook at that position. And that's where personally I see that that has to be changed to address this kind of a situation. The other is that why can't UN do that in terms of accommodating, taking care of refugees? Now, for good or bad reasons, this planet is divided between states. I mean, they hold the territory, they maintain everything. I mean, our organizations have a limited probably role in terms of controlling the territory part of it. So to accommodate people, you need to have it. So in that sense, I think states remain central to in terms of accommodation of refugees. No others have it. The concept of state monopolized everything. So that's including international to a large extent. So it's very difficult in terms of thinking, accommodating refugees in any other sense. The other is the question of terrorism and refugees. Now, first of all, this is a very uncomfortable thing of there is something called already a given terrorism. So personally, I don't want to take it that as there is something terrorism and terrorists and they get into your borders. People come, terrorists, quote unquote, those who indulge in violence, belong to a country of any country. And that's a different framework. Even if somebody is coming from somewhere and doing it, you have your own mechanism of law and order, whatever the mechanism is. Why you jump into it and say that all the terrorists would create, all the immigrants or refugees would create terrorism? And somewhere I think this whole question of the misplaced one of equating one with the other, despite the fact that there are instances of maybe people are coming and doing that violence happens everywhere. I mean, a large number of violence happens in South Asia, which is an inbuilt violence. It's not coming from anywhere else. India suffers from many forms of violence. So it's not something that somebody is coming from outside and create. Even if something happens in that sense, there would be a different legal mechanism to deal with that, which is a law and order criminal law framework which should come in picture. So that should not be really equated with the granting of refugee status, accepting immigrants from somewhere. I mean, there is a logic which most of the times West gives also. I mean, that's what the prevalent logic that you have it. And that's how the post 9/11 situation, in fact, brought in many things which, in fact, compromised with refugees' rights, human rights, and many things. Thank you.